The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Good afternoon. We have 3 cases to be submitted this afternoon. Those cases are State of Iowa versus Troy Dowell, State of Iowa versus Theodore Gathercole II, and State of Iowa versus Justin Marshall. We'll now hear the arguments in the Dowell case. Mr. Audlehelm, you may proceed.
May it please the court, counsel. Your honors, again, it is an honor to be before this court. I appreciate the court taking this case on further review. What the court has before it is a truly breathtaking chain of facts that has led to a spotlight being shined squarely on several procedural issues, and I think this case is a great opportunity for the court to give guidance to district courts and the litigants as to what is supposed to take place at a 664A no contact order extension hearing. I think the first question is whether Troy Dowell, as the defendant and the enjoined party, does or does not have a right to an attorney. And then I think there are several reasons why he may. There's reasons as to this case specifically, and then there's a larger question of a critical stage of the proceeding. Depending on which of those, if the court selects that he does have a right to an attorney, depending on which of those, it's important to specify which. And then there's several procedural questions that then follow from the court's.
Couldn't it be maybe the other way around? In other words, don't we sort of first have to decide if you can get hearsay reports into evidence at a hearing on extending a no contact order? If you can, then doesn't your whole case kind of go away?
If I understand the court's question is if the strict rules of evidence of a trial don't apply at an extension hearing one way or the other, then does the right to counsel really attach?
Does it matter? Because you had a lawyer there. There was a lawyer there. The lawyer, though, didn't object to the admission of this report from this Australian therapist. And if hearsay doesn't apply, then the report could come into evidence and the lawyer didn't breach some essential duty, and we don't need to reach this question about whether there's a right to counsel or not.
I think there's 2 answers to that. The first answer is, at a minimum, I believe it was the law of the case that Jenny Russell was Troy Dowell's attorney. The reasons for that being both the 2013 reappointment of her by the district court, which I think under Patchett produces a reliance ability in a defendant, and also Jenny Russell's litigation in 2010 on Troy's behalf of the pro se motion to modify he filed. And the other answer is, more generally, I think that the analogy would be the rules of evidence don't strictly apply at a sentencing, nor is there a burden of proof. But what would happen if a district court relied on instead of a victim impact statement that's normally given at a sentencing, what would happen if the district court relied on a therapist letter from someone that a therapist the defendant had seen and the defense never objected to that?
Isn't the issue more basic, though, that the report was received the day before, no one saw it till the day, no one had a chance to prepare for it, no one had the chance to hire witnesses to rebut it, and we do know the burdens. There is a burden in this case, at least on the defendant, to show that he's no longer a threat. I mean, so, whether the report comes in on hearsay or not, and in fact, if the report does come in on hearsay where you don't have the person there, doesn't it become more critical to be able to prepare to meet the report? I mean, aren't those the issues? I mean, I understand there's all kinds of issues whether it comes in or not, but it's a little more basic than that. I mean, at least have somebody there to do something for you based upon the evidence that's going to be presented against you.
Yes, Your Honor. I went through the transcripts again, and in the June 25th hearing, Troy Dowell was put on the phone, and the only notice he had was the notice from the prison saying, hey, be in this phone conference room. That's the notice to which he's referring, and he says on the phone, I don't know what's going on, I haven't seen anything. And they were able to find him, to give him to have him served by process server, or at least by prison counselor, who signed an affidavit after they extended the no contact order, but they weren't able to do that beforehand, apparently. And then Jenny Russell was appointed and given less than a week to prepare. So I think that's,
What was the evidence that she ever got the report?
oh, I'm not sure she did.
Except the day of the hearing. That's how I read the record.
Yeah, and I think that at best, the record shows this is still paper. So at best, the record shows the State's Exhibit 1, the little sticker says July 2nd. Or was that yeah. So I think that, I think that at a minimum, post-conviction relief proceedings are needed to sort out what happens during that week. So I think that does that answer the court's question? With the larger notice issues, the statute, what's puzzling with the statutes is that they don't assign any requirement, and I find this quite unsettling. The statutes in 664A, they actually give no requirement of notice upon the defendant. So I suppose there could be defendants out there who are simply evading service, and maybe some of the more problematic ones. But at the same time, you'd have to give some of these enjoined parties notice of the extended no contact order before you could justify convicting them of it anyway. And this isn't a case where they didn't know where he was. So this is a case where it wasn't even the victim, it's the legal guardian of the three victims. Troy's ex-wife emails from the other side of the planet a request to the county attorney to extend the no contact order, and the record actually also indicates that the county attorney tried to get her on the phone and couldn't. And so they filed they essentially viewed themselves at the county attorney's office as having a duty to litigate the extension on behalf of Charity, and they got the no contact order extension on file 1 day beforehand. So I think there's a larger issue of notice of, you have a statute that essentially allows private citizens to either deputize themselves as county attorneys, or it allows them to send an email from the other side of the world and commandeer an entire prosecutor's office into litigating on their behalf. So I think that, and then I think the larger notice issue is what exactly is supposed to be litigated at these hearings? Because if it's simply, here's a quick hypothetical based solely on the facts of this case. Originally, there were 4 protected parties. There were the 3 children, and then there was the Drake student. They never tried to request the extension of the no contact order as to the Drake student, but I'm sure she feels exactly the same way as she did before, that she doesn't much want to be peeped on by a stranger while she's in the shower. They didn't extend the no contact order as to her because she moved away from Drake.
Aren't you getting ahead of yourself, or don't we have to decide that at that hearing he was entitled to effective assistance of counsel? And then if we make that decision, and I don't know what we're going to do, but if we do decide, then the question is, can we decide it today, or do we have to send it back for a post-conviction relief? Or do you have to bring it by post-conviction relief? You can't bring it by direct appeal. It's sort of like a parole revocation. Aren't those the issues we have to decide first?
I think so, and there's several procedural questions. I think that the cleanest thing to do would be to remand it for further hearing and simply clarify. I think the larger question is that and I appreciate that I'm going back to where I was a second ago, but the question at this hearing, I think, needs to be whether the whole situation has changed, not solely whether Troy Dowell himself has changed. And that would allow the district court to take into account the fact that the protected parties on the other side of the planet and don't frankly need the protection of this hearing anymore. And then but the court is correct in noting there are several procedure issues that we're going to need to be decided. I think that whether it's a remand or a post-conviction case would have to be premised on the assumption that there is a right to counsel at the hearings, and also why. I think whether the right to counsel attaches because the protected parties were Troy Dowell's children that he has a fundamental right to contact, or whether this is a critical stage of the proceedings, which would be a broader question.
We don't even know if his attorney contacted this therapist by phone and made a conscious decision not to do anything, do we?
That's right. So I think a PCR would be the way to litigate that. There would be I think that would be the fairest way to go about this. So I think that, and the other thing that I think is really noteworthy is that the entire proceeding really wanted Troy to have an attorney. I think it's pretty clear they didn't want to deal with him directly.
You got to go back and tell me why he's entitled to counsel at this stage of the trial.
Well, there's three ways to get there. I think the first is, and I was alluded to it earlier, just solely by law, the case doctrine, the fact that they so consistently appointed not just an attorney, but the exact same attorney. Indeed, she was responsible, or viewed herself as responsible for litigating Troy's motion in 2010 that he filed pro se. So I think under Patchett, Troy had a reliance interest on the effective representation of his counsel. This is a no-contact order that stopped Troy from having contact with his children, yet there was never any kind of China case filed, so he lost all of his rights that he would have had a juvenile court action been filed. But then the larger question is that I would argue this is indeed a critical stage of a criminal proceeding. So based on my reading of the case law of when your critical stages are, I think that this case falls right between supplemental restitution hearings and modification of restitution hearings, with supplemental being where you do have the right to counsel and modification restitution where you don't. With the modification restitution hearings, what's happening at those is you're still agreeing, yes, Your Honor, I agree I owe this dollar amount of restitution, but you're requesting the court to modify the payment plan, so it's more like a civil judgment debtor availing himself of those protections. At a supplemental restitution hearing where the court has found that there's a right to counsel, the reason being it's a second sentencing in a way. It's a sentencing that couldn't be done at the initial time of sentencing by happenstance. So I think the argument here would be that in a way, this is like almost a second sentencing after 5 years after the initial one, where the court is making a finding that Troy Dowell continues to oppose to a threat for the years 2013 to 2018. So I think that's where you can start with. There is a right to an effective attorney at that, since it's a critical stage of the proceeding.
Don't we have a choice to refrain from deciding whether there's a right to an attorney based on the fact he had one, and once he had one and is relying on her, if we determine she was ineffective, we can decide it on that basis?
Yes, I think that's... There are ways the court can refrain from deciding many larger issues in this. It can be decided solely based on, once you're given an attorney, you have a right to rely on that attorney, and that's it. So I would agree. I think that the questions of whether it's a critical stage and the questions of whether it's a critical stage, whether it's your children or not, those can wait for another day, as can the issue of what would happen if someone was convicted of a no-contact order 7 years after it was initially put in place because they didn't get notice of the extension 2 years before that. So I would agree, and I think that might be... There are many other issues in terms of what the state's obligation is to give people notice, because the statute does such a poor job of creating any kind of effective notice requirement. So I think, yes, I think that there are ways to decide this case on a narrow basis. So, and I think one of the last hypotheticals that I'd like to touch on is whether, and this touches to whether the proof was sufficient at this hearing to demonstrate Troy continued to be a threat to his children. These children were 1, 4, and 7, and I think at the time of the crime, and 1, 5, and 7, I think, at the time of the sentencing.
But that's his burden. What evidence is in the record to show that he's no longer a threat to them?
My argument is solely the fact that they're in Australia ought to be enough.
We're talking about both mental and physical threat, and you could do a lot of damage over the phone.
Well, and my question then would be, is it even realistic? There's two answers to that. The question is it even realistic that they're going to have any phone contact? So I think a rehearing, not necessarily a PCR, but a rehearing would be fair toward Charity Schneider and the children, because maybe they are planning to coming back to visit stateside, and maybe there is some time he'd be able to get out. So I think that's a fair question. But I think that he's not gonna be out till the second restraining order's over, is he? And you can't extend it another time, I don't think. No and yes. He could be out in the middle of this second restraining order, and by the statute, there's no limit to the number of extensions. So the point is that with this, The way this is set up now, these children can become adults and continue to place a permanent restriction every 5 years on Troy's ability. Not that I doubt they much want to have any contact with them. I don't know how you arrange it even if they could. But I think a larger issue is that the hearings need to also focus on somehow tying this back, whether he's a threat or not. They need to focus on somehow tying this back to the original crime he was convicted of. And the reason why that's so important in this case is because, first of all, 664A.13 defines the victim as physical, emotional, or financial harm. Well, as the children keep getting older, which by itself would be a change of facts, I think, you can leave an 11-year-old probably, and a 15-year-old and a 17-year-old definitely, home alone for half an hour without committing child neglect. So I think hypothetically, if they were all still here, I think that looking at the situation having changed would be a fair topic of discussion for the district court. Does the court have another? Okay, I'm I think I'm out of time, so thank you.
Thank you as well, Counsel. Ms. Chambers.
May it please the court. I'd like to start by clarifying what issues are and are not before the court today. The defendant has conceded that he bears the burden of proof, so that issue is now properly before the court. He also concedes that there's no statutory right to counsel, and he does not argue at any point in any of these proceedings that there's a right to counsel under the Iowa Constitution. So the only two issues before the court are whether there's a Sixth Amendment right to counsel and then the evidentiary issue. Under the Sixth Amendment, the issue, the determining factor of to whether the right to counsel attaches is whether it's a critical stage of the prosecution. This is clearly not a critical stage, and it's clearly not even part of a prosecution. If you look at how Chapter 664A works, the initial determination about whether there should be a restraining order, or a no contact order rather, is made at the initial appearance. At the initial appearance, the magistrate looks to see whether the offense is one covered by this chapter and whether the defendant poses a threat. Again, if you look at the statute, then when you get to the sentencing hearing, the statute does not seem to give the district court discretion to deny the no contact order if the magistrate's initially issued one, and if the offense meets the requirements of the statute. And then when you get to the 5-year extension hearing, the statute clearly says the no contact will be extended unless the court finds the defendant no longer is a threat. When we look at how this plays out, so at the initial appearance where this initially is going to be issued, the victim's not likely to be there. Prosecutors generally not there. And for other purposes of the right to counsel, we've generally held that at the initial appearance, the Sixth Amendment does not apply. At the time of sentencing, clearly there would be a Sixth Amendment right to counsel because of the sentencing. But the fact, and just as a practical matter, the fact that the decision to either terminate the initial temporary order or continue it is made as a part of sentencing, so as a practical matter, there's going to be an attorney there. But when you get to the 5-year extension, those don't even have to be brought by the state. So you would have the situation where the defendant is claiming, I have a right to counsel under the Sixth Amendment, but the victim is there by his or herself, without the prosecutor, without an attorney.
The cold legal argument, what you're saying makes a lot of sense. When it kind of wrapped into the context of this case, it's a little more troubling. I mean, sort of you have the fact that to begin with, one could argue that really the primary victim in this case was the Drake student and not the kids. And then another kind of troubling aspect of the case is it does seem as if the no contact order is effectively acting like is having the function of a termination of parental rights, because with the no contact order in effect, it's very hard to be a parent. And if there were a termination of parental rights proceeding, clearly Mr. Dowell would have a right to counsel. And then kind of the third thing that kind of troubles me, sort of looking at kind of the overall mix of stuff, is that maybe Mr. Dowell is being penalized for these shenanigans at the Los Angeles airport that occurred in the past. That obviously that was significant wrongdoing, but should it determine his rights going forward? So, I know this isn't really a question, and I apologize, but do you see that there's sort of an underlay here that's maybe a little troubling about the case?
I do. I think what troubled the dissent in the Court of Appeals, and which I suspect is troubling you, and frankly it gave me some pause, is in some sense this is a termination of parental rights, but when on deeper investigation there really isn't. So first of all, there is that proceeding, and the state may have, or the mother may have, chosen to pursue termination, but for the issuance of the no contact order. So really the no contact order is the less intrusive remedy here. It doesn't forever foreclose him from parenting. He is still the father. At some point, at the point at which he no longer poses a threat to his children, he can resume that relationship, whereas a termination is permanent. I would also point out that while there is a right to counsel in termination proceedings, and there are a number of different ways that private and state-initiated terminations can occur, but the court has found those are statutory rights to counsel, and then they've applied them to defendants under the Equal Protection Clause, not under the Sixth Amendment right to counsel. So if you look at Cromwell, for example, there the court, I think I can give you the site, there the court said, we're going to find a right to counsel for indigent parents in this privately pursued termination proceeding, but not as a right to counsel, but only because as a matter of statute, the state would provide that in a state-initiated proceeding, and as a matter of equal protection.
But in that case, we didn't have to go to the Iowa Constitution where it's written differently.
We did not.
Because we went to the equal protection.
You did. I would point out again, though, that the state constitution has not been raised or briefed or even cited.
He talks about on page 14 of his brief, he mentions under the Iowa and federal constitution and under our air preservation, that has been enough for us.
Okay. And you can reach it. Again, though, the test is the same for the most part, and I recognize the court could provide some expansive protection under the Iowa Article 1, Section 10, but the issue has always been, is this a critical stage?
Could we kind of have a limited right and recognize sort of a right to counsel in a no contact order when the no contact order is going to have the practical effect of maybe terminating the individual's parental rights? I mean, could we recognize just in that context, because that's what's a little bit, again, unusual here. It's not no contact with a stranger, it's no contact with your own children.
That would be a constitutional finding, I'm assuming. The court could do that. It would fundamentally change the nature of the proceeding, because then I think the district court would have to make a determination whether continuing the no contact order would amount to a termination. Like once would it be a termination? Twice would that amount to termination? It becomes a little more complicated. And also here, is the amount of contact appreciably decreased by the no contact order? I mean, he's in prison, so the only contact he could have had here would be phone or internet contact, whereas a parent who wasn't incarcerated could have all kinds of, the regular sort of parental contact.
The suspicion is, reading the record, that, no disrespect to the mother, I don't have any reason to question her motives, but in effect, what's happening is sort of she's getting a parental termination, a de facto termination of parental rights, kind of without going through all the procedures that would be required for that.
I can see that argument. Again, though, her alternative would just be simply to start a termination proceeding. And I'm not sure that's a more protective alternative for the defendant.
And then there would be more protections. You're right. I think the outcome might well be the same,
right.
But there would be a right to counsel. There would be standard, the primary being the best interests of the children, as opposed to simply a continuation of this no contact order. And again, I might view it differently if the no contact order were put in place because of, in a different factual context. But in this context, he left the kids alone and then went and did something very wrong over at Drake. But I think it would be hard to say the kids are the primary victim here.
We're a little bit handicapped in knowing what the factual setting is, because at the sentencing hearing, the defendant just said, yeah, I agree that the no contact order should be issued. And at the extension hearing, while he presented some evidence, it wasn't horribly enlightening on the issue. But if you look at some of the exhibits the defendant offered, it included an order from the district court in the marriage dissolution case and the subsequent custody hearing, at which the judge made reference to the fact that the defendant admitted that he had sexually acted out in the presence of the children but he was intoxicated. So, and if you look at the trial information, the defendant was charged with child endangerment and neglect of a minor. So it isn't clear to me, and the record just frankly doesn't tell us, but it isn't clear to me that it is merely leaving them home alone.
I had forgotten that.
You know, in ARS, we held that the statute, once you give a right to a counsel or given a counsel, you have a right to effective counsel, because the statute never said in termination cases you have a right to effective counsel, you just have a right to counsel. And going back to Justice Waterman's question, the court determined that he was entitled to counsel, as I read the beginning of the hearing, and the county attorney didn't object. So, I mean, solely on the basis when the court says, I think he's entitled to counsel, the county attorney says, yes, he's entitled to counsel, can't we just take the reasoning from ARS and say, because you provided him counsel, it has to be effective? And maybe it won't apply to the next case, and we could argue whether you're entitled to one or not, but I think if you look at ARS, they took a statutory right and turned it into a constitutional right once you were provided a counsel.
If the state agreed that there were a statutory right to counsel, the state would agree that there was a right to effective counsel. The state does not agree that there's a statutory right.
State never objected to him having counsel there when asked about it.
They didn't. That isn't the same as conceding that there's a statutory right. The state certainly did acquiesce in the appointment of counsel, and if the court were narrowly to say, because the court appointed it, there's a right to effective assistance, on one level that seems okay, but when you take a step back and think about it, then how will that be enforced? As I read Chapter 822, no PCR proceeding would be available to determine whether counsel was ineffective. And if what counsel is alleged to have done ineffectively happens on the record, then maybe not such a big issue. But what if
One thing we could do in the limited circumstances is remand the case, leave the no contact order in effect until it's finally decided, and have counsel do what he or she would have done if there is a question of ineffectiveness of the counsel, or remand the case for the court to decide whether he or she was effective at the time, and if he or she wasn't, then have the hearing. I mean, we could limit it to this case very, very clearly.
Were the holding limited to this case, frankly, the state doesn't have a huge objection. It's not our budget. The public defender might have an objection, but we don't really have a dog in that fight. If the holding were limited to this case, and it were very clearly stated that the mere acquiescence in the appointment of counsel entitles a defendant to effective assistance, because that's not true for the most part, and it's not true here. People have attorneys in civil cases all the time, and people have attorneys in civil matters that are very closely related to criminal cases all the time, but they do not have a right to effective assistance.
But this is not a similar case. It's captioned as a criminal case. It's an extension of sentencing, you could argue. You heard the argument. It's not really a civil case. It seems to be more important than a restitution order, because you're taking away more than just a person's money. You're taking away their, what the U.S. Supreme Court says, there's a right to see your children and to raise your children. And I know it's limited, but, I mean, it seems to be a little bit more than just a civil case here.
It always gives one pause when a parent is prevented from having contact with his or her children. But the rule that the defense is asking for here is a general rule where there's a right to counsel under the Sixth Amendment anytime there's an extension of a no contact order. That is not that can't be justified by concerns about in this particular case. So let me just point out a few of the reasons why I think this is not a critical proceeding. A critical stage of prosecution is those stages where the state has amassed its vast resources against a defendant. Here, we don't even need to have the state. We can have a private individual. Often, the protected party will not have an attorney. And there's nothing trial-like about these no-contact order hearings. In fact, I would submit that there's almost never a hearing at all. Everything's on paper, the court looks at it, the presumption is it will be continued, and unless the defendant shows some reason why it should not be continued, it's done sort of as a matter of course.
But doesn't that make it more important for the person who wants to not have it extended to have somebody, especially when they're in jail, to stick up for them in a criminal proceeding? Because I don't think that, I'm not going to say this, but there's a real question whether the confrontation clause applies in these sentencing hearings or these extensions. There's a real question whether or not the hearsay rules apply. I mean, if you're going to say this is a sentencing hearing and confrontation clause doesn't apply and hearsay doesn't apply, then you've basically said it's a criminal type proceeding because we're applying criminal rules to something that you said isn't criminal.
Let me give you one last, I think, really compelling reason. The right to counsel clearly does not apply to simple misdemeanors where incarceration is not contemplated, whereas Chapter 664A does. So you would have a situation where in the criminal prosecution, that defendant would not have a right to counsel, but when it got time to extend the no-contact order, suddenly a right to counsel would kick in. That just does not seem like a rational interpretation of the Sixth Amendment. Thank you.
Thank you as well, Ms. Chambers. Rebuttal?
It's 5 minutes, right? Thank you. Thank you, Your Honors. In rebuttal to what the state has presented, the state's position is that essentially this isn't a critical stage. But all of the reasons why the state's saying it's not a critical stage, to me, prove that it is. I think that the idea that the victim on her own, and of course, I mean, I'm using her and him just to be consistent with the case, but the idea that the victim can on her own initiate a new restriction on someone's liberty without any kind of vetting or oversight, or what has clearly been proven in this case, which is that the county attorney's office lets itself get commandeered by people, that's certainly a hearing at which you should have a right to counsel. I think whether it's a critical stage so it's statutory or whether it's solely constitutional, I think that's absolutely where you should have a right to counsel. And the idea that these aren't a trial-like proceeding, I mean, the implication was kind of raised why I didn't question the burden of proof, which I chose not to. So if that is an issue that's a live issue, then I was ineffective for not having raised it, frankly, and that should be preserved. But the fact that we're talking about PCR remedies in this indicates why it's a criminal proceeding. I mean, there aren't civil remedies for what's been done here. And I think part of back to why it's a critical stage, I think that just the assignment of a burden of proof, whether it's been assigned the right way or not, just the assignment of a burden of proof indicates that it's a trial-like proceeding. I mean, the applicant has a right to counsel in a PCR, but the applicant still has to bear the burden. And even if most of these hearings are just done on paper as sort of a matter of course, that's hardly the case of what happened here. This was a fiercely litigated issue where a man barely had any realistic knowledge of what was taking place in the courtroom, and he could barely hear on the phone. So,
well, I'm going to circle back a little bit, I think all the way to Justice Mansfield's initial question here. I'm thinking that this is something that we can avoid. We're not going to get into this idea or make a final determination about whether or not this was a critical stage of these proceedings or not, because counsel was there. My main concern at this point is I don't know that we have a sufficient enough record to determine if counsel is there and has been appointed, then I think they're entitled to effective assistance of counsel. So, and I think you said this earlier, are you then asking that we remand it for purposes of a hearing to simply determine whether this attorney was ineffective? And it goes back to another question that I think Justice Wiggins asked about whether or not the hearsay comes in or not. because, I don't really know on this. We've heard a lot of arguments in the briefs about, well, the rules do apply or they don't apply. I don't really know right now whether they do or they don't apply and whether there was any need to object to this anyway. But I'm just not, I don't think I need to decide the critical stage of this proceeding right now. Is that what you're asking for? Or tell me what you're really asking for, or what relief you're asking for.
Well, Your Honor, I think that I generally do agree that judicial restraint is the best approach, and going incremental is the best approach. I think this is a case that can become a vehicle for the court to raise larger questions and to use some of its supervisory power, but I agree it's not necessary in this case. I think it can be decided on a much more narrow basis of just trying to figure out what happened at this hearing. And I think if anything, if nothing else, it can be an invitation for the legislature to write a better statute where they can delineate, okay, well, is this a second or a third kind of mini trial, or is it like a sentencing where Strickland applies but the rules of evidence don't? And I would respect that approach. I think that might be a very prudent approach, given that the facts of this case are so bizarre that I can see it can become an avenue for very bad law if it's allowed to chain out. And in response to Justice Manfield's question to Ms. Chambers, I think that it also could be limited to, and I think this is something that really emphasizes what a unique and almost cruel case this has become, because the court could limit it to a situation where you have a right to a lawyer if a no-contact order stops you from seeing your children. But that would pretty much limit it to only this case, because in pretty much every other case in the world, there would be some kind of legal proceeding going on about why you couldn't see your children. There would be a criminal case about you had done something to your children and you should be punished for having acted out sexually in front of them. Nothing like that was brought here. Or there's a juvenile court proceeding where there's the state allowing you to take some kind of parenting classes or something. And what's ultimately so troubling here is that the very real possibility exists that a private citizen who's now in Australia commandeered the county attorney's office to do the heavy lifting in her divorce. Thank you.
Mr. Audlehelm, thank you as well. The case is submitted. We'll now hear the arguments in Gather Call.